Welcome back to Universal Insight. Please subscribe to my channel and press the bell icon for more updates. Why are there not more people talking about the Supreme Court's silence on gun bans? The Supreme Court's silence on gun bans has thundered across America. Millions demand bans on powerful firearms, while millions more see any restriction as an attack on their rights. This isn't just legal wrangling, it's a battle over safety, liberty, and the meaning of the Second Amendment. The court's recent move didn't resolve the fight, it set the stage for a bigger showdown. The core question: can states or counties ban the AR-15, America's most popular rifle? Gun control advocates call these weapons of war, pointing to tragedies and demanding action. Gun rights supporters argue the Second Amendment protects ownership of effective self-defense weapons, and that bans punish the law-abiding. The conflict is now focused on Cook County, Illinois, home to one of the oldest assault weapon bans. That law has survived before, but the legal landscape changed after the Supreme Court's 2022 Bruin decision. Now, every gun law must fit with America's historical tradition. This new standard puts Cook County's ban in the crosshairs. The nation is watching to see if this old law will survive the new test. The next chapter in the gun debate is about to be written. The stakes have never been higher. On June 2, 2025, the Supreme Court declined to hear two major gun ban cases, one from Maryland, one from Rhode Island. Gun rights groups wanted the court to strike down these bans using the new Bruin standard. But the court simply denied cert, leaving lower court decisions in place. This wasn't a ruling on the constitutionality of the bans, just a procedural move. For gun control supporters, it was a temporary win. Their state laws remain for now. For gun rights advocates, it was a frustrating delay, not a defeat or a victory. The court's silence left millions under laws they believe violate their rights. No final answer was given, just more waiting. The legal fight continues, and the Supreme Court's inaction only intensified the debate. Both sides are left in limbo, watching for the next move. The real battle is still ahead. The decision to wait wasn't unanimous. Three conservative justices, Thomas, Alito, and Gorsuch, dissented, urging the court to take up Maryland's ban immediately. Justice Thomas argued the lower court misapplied the Bruin test and that AR-15s are in common lawful use. Justice Kavanaugh, while not joining the dissent, warned his patience is limited and pointed directly to the Cook County case as the one to watch. These signals show a majority of justices are skeptical of assault weapon bans. The court is waiting for the right case to make a definitive ruling. The spotlight is now on Cook County, Illinois. The stage is set for a landmark decision. Supreme Court actions often spark confusion and rumors. After June 2nd, false stories spread. Some claimed the court upheld all assault weapon bans. Others said the DOJ was ending all bans. In reality, the court simply declined to hear two cases, setting no national precedent. The DOJ is challenging Illinois' statewide ban in lower court, not eliminating all bans. The truth: the court's inaction left Maryland and Rhode Island laws in place, but said nothing about other states. Legal battles continue across the country, each decided under the Bruin standard. There's no nationwide answer yet. The Supreme Court did not uphold or strike down any bans. The dissenting justices signaled readiness to rule but haven't acted. The fight is far from over. Rumors of a final victory for either side are premature. The most important decisions are still to come. Supreme Court procedures are complex, fueling public confusion. Most people think the court must rule on every case it receives, but it hears only a tiny fraction. Denying cert is common and means nothing about the law's merits. The media often spins these denials as victories or defeats, misleading the public. Social media amplifies simple but inaccurate headlines. A denial is not a ruling, it's a wait and see. The real story is often lost in the rush for quick answers. Understanding the difference between a ruling and a refusal to rule is crucial. Only then can we see the situation clearly. The truth is rarely as simple as a headline. Now, the nation's focus shifts to the 7th Circuit in Cook County, Illinois. Two major cases are underway, one against Illinois' statewide ban, the other against Cook County's long-standing Blair Holt assault weapons ban. Justice Kavanaugh highlighted the Cook County case as the one to watch. In August 2025, gun rights groups petitioned the Supreme Court to hear their challenge to the Cook County ban. The justices must soon decide whether to take the case. If they do, arguments could happen in 2026, with a nationwide ruling by summer. The outcome will affect not just Illinois, but every state with similar laws. The Supreme Court hasn't ruled yet, but the wait may soon be over. The dissenting justices have signaled they're ready. The question is no longer if the court will decide, but when. All signs point to a decision soon. To understand what might happen next, it helps to look back at how the Supreme Court has handled similar cases in the past. Over the last 2 decades, landmark decisions like District of Columbia v. Heller in 2008 and McDonald v. Chicago in 2010 reshaped how courts interpret the Second Amendment. In Heller, the court recognized an individual's right to possess firearms for self-defense, while McDonald extended that right to all states. But since then, the court has often declined to take up new gun law challenges, letting lower court rulings stand. This cautious approach changed in 2022 with New York State Rifle and Pistol Association v. Bruin. That decision set a new standard, requiring gun laws to be consistent with the nation's historical tradition of firearm regulation. Now, with the Cook County and Illinois cases, the Supreme Court faces fresh questions. Do bans on certain types of firearms fit within that historical tradition, or do they go too far? Legal experts say the justices' past opinions offer clues but no guarantees. This time the stakes are higher, and the court's answer could redefine gun rights for a generation. As the nation waits for the Supreme Court's next move, legal experts and advocates across the spectrum are weighing in on what the future might hold for gun laws in America. Some predict that a sweeping decision could upend decades of firearm regulations, forcing states to revisit, or even repeal, long-standing bans and restrictions. Others believe the court may issue a more narrow ruling, leaving much of the current legal landscape intact while clarifying specific points of law. Policy analysts warn that either outcome could spark a wave of new lawsuits, as both gun rights and gun control groups test the boundaries of the ruling. States with strict gun laws may see immediate challenges, while those with looser regulations could use the decision as a blueprint to further expand rights. Experts agree on one thing: the court's decision will ripple far beyond Cook County, shaping not just the letter of the law, but the daily lives of millions of Americans. Whether it signals a new era of deregulation or sets firmer limits on the right to bear arms, the coming months will be pivotal in defining what the Second Amendment means in the 21st century. For lawmakers, citizens, and courts alike, the message is clear: prepare for change, and for a national conversation that's far from over.